Trademark is more than just a logo or a name. It's a mark that can be represented graphically and is distinctive enough to help consumers differentiate the goods or services of one trader from those of competitors. This includes devices, brands, labels, tickets, names, signatures, words, letters, numerals, shapes, packaging, or even combinations of colors. The definition is broad, allowing for both conventional and non-conventional marks. The communicative ability of a mark is central. It enables traders and the public to quickly identify which signs are already claimed, making the marketplace more transparent and efficient. Trademarks serve several important functions. They identify the goods of a particular manufacturer, indicate their origin, and establish a connection in the course of trade. A trademark assures the quality of a product and acts as a symbol of goodwill for the business. It also advertises the product and protects users from confusion and deception by distinguishing the source of goods and services. If consumers believe all items bearing a symbol come from the same source, the trademark has acquired its source-identifying property. Over time, trademark registration became institutionalized, providing statutory protection and reinforcing the importance of distinctiveness. Distinctiveness is the cornerstone of trademark protection. According to the Trademarks Act, 1999, a trademark must be capable of being represented graphically and must distinguish the goods or services of one person from those of others. This includes shapes, packaging, and color combinations. The initial registration lasts 10 years but can be renewed indefinitely. Distinctiveness can be inherent in the mark or acquired through use over time. The ability to distinguish is what makes a trademark protectable, ensuring it performs its essential function in the marketplace. Abercrombie formulation, developed in Abercrombie and Fitch Covey Hunting World Inc., provides a spectrum to measure trademark distinctiveness. Marks are categorized as generic, descriptive, suggestive, arbitrary, or fanciful, and invented. Generic marks like milk for milk are not protectable. Descriptive marks may qualify if they acquire secondary meaning. Suggestive marks hint at the product's nature but don't directly describe it. Arbitrary or fanciful marks have no inherent relationship to the product and receive strong protection. Invented marks, being entirely new, are afforded the strongest protection. Generic marks are not distinctive and cannot be protected as trademarks. If a seller could trademark a generic name, other sellers would be unable to describe their products, putting them at a disadvantage. Words like milk for milk or hiking boots for boots are considered public property and cannot be appropriated. The law ensures that generic terms remain available for all traders, preserving fair competition and preventing monopolization of common language. Descriptive marks identify attributes of a product, such as purpose, size, color, ingredients, or origin. Generally, they do not qualify for protection unless they acquire a secondary meaning. This means the public must associate the mark with the manufacturer or seller, not just the product. Examples include Jiffy Lube and surnames like McDonald's or Hilton Hotels. Once a descriptive mark becomes linked in consumers' minds to a specific source, it can be protected as a trademark. Suggestive marks do not directly describe the product but suggest its nature or characteristics. Consumers must make an inference about the product, yet there is still a relationship between the mark and the product. For example, Pathfinder suggests off-road capability, and Titleist hints at championship sports equipment. These marks are protectable because they require imagination to connect the mark to the product, making them distinctive in the eyes of the law. Arbitrary and fanciful marks are highly distinctive. They do not describe or suggest any characteristic of the product. When a symbol or word has no inherent relationship to the product, it is more likely to be associated with the brand. Examples include Apple for computers, Yamaha for motorcycles, Chevron for gasoline, and Maytag for appliances. These marks are understood to be fanciful and receive strong legal protection due to their uniqueness. Invented marks are entirely new words or symbols created by the brand. These marks are inherently distinctive and receive the strongest protection under trademark law. Their uniqueness ensures that consumers associate them exclusively with the brand, making them powerful tools for building identity and reputation in the marketplace. Trademarks Act prohibits registration of marks that exclusively designate the geographical origin of goods. Only geographical names used in an arbitrary or fanciful manner may be registrable, such as North Pole bananas. Rule 102 allows parties to request refusal or invalidation of trademarks containing misleading geographical indications. This ensures that consumers are not confused about the true origin of goods and maintains integrity in the marketplace. Distinctive character refers to a trademark's capability to distinguish goods or services. Words like best or superior are merely descriptive and do not qualify as distinctive trademarks. However, even descriptive marks may be registered if they acquire a distinctive character through use or become well known. The Supreme Court has clarified that a descriptive mark may be protected if it assumes a secondary meaning that identifies it with a particular product or source. Registering a trademark confers several advantages. It grants exclusive rights to use the mark in specified commercial activities, enables traders to protect their mark before market introduction, and creates a presumption of validity. Registration reduces disputes by increasing certainty about the scope of protection. However, registration does not prevent others from suing for passing off, and acceptance of an application is subject to review and possible refusal by the registrar. There are absolute and relative grounds for refusing trademark registration. Absolute grounds relate to the intrinsic qualities of the mark, such as lack of distinctiveness, descriptiveness, or generic nature. Relative grounds concern conflicts with earlier trademark rights. The registrar may refuse registration if the mark is likely to cause confusion, is devoid of distinctiveness, or is prohibited by law. Marks must not hurt religious sentiments or be obscene, and shapes necessary for technical results or substantial value are excluded. To assess if a mark has attained secondary meaning, factors such as customer perception, exclusivity of use, manner and duration of use, volume of goods marketed, advertising, and consumer surveys are considered. The relevant class is defined as average consumers who are reasonably informed and observant. Marks are viewed as a whole, and even if parts lack distinctiveness, the overall impression matters. Simple color marks are usually treated as devoid of distinctive character unless they significantly depart from the norm. Shape marks must significantly depart from the norm or customs of the sector to be distinctive. The assessment focuses on whether the shape is unusual or idiosyncratic, making it memorable to consumers. The shape must indicate the source rather than being merely functional or decorative. Shapes that perform technical functions or are protected under design law are excluded from trademark protection unless they fulfill the essential function of distinguishing the goods. Descriptive signs or indications are excluded from trademark protection if they characterize the goods and services. The association between the sign and goods must be specific and direct for exclusion. This test applies to pictures, shapes, colors, and words. Customary and generic marks are excluded to keep them available for all traders. However, if a mark becomes synonymous with the good through long use, it may be registered. Marks contrary to public morality, those that hurt religious sentiments or are objectionable in content, are not registrable. Marks protected under the Emblems and Names Prevention of Improper Use Act 1950 are also excluded. The law aims to protect public interest by ensuring that trademarks do not offend or mislead consumers. Relative grounds for refusal focus on conflicts with earlier trademarks. If a mark is identical or similar to an earlier trademark and covers similar goods or services, registration may be refused to prevent consumer confusion. The registrar must protect well-known trademarks against identical or similar marks, ensuring that the interests of bona fide traders and the public are safeguarded. Well-known marks are recognized for their reputation among a substantial segment of the public. Their use on unrelated goods or services is likely to indicate a connection with the original owner. Well-known marks receive broader protection, preventing unauthorized use that could harm their reputation or cause confusion. The law aims to prevent unfair exploitation and dilution of well-known marks, ensuring their integrity across different markets. Registrar considers several factors when determining if a mark is well-known: public recognition, number of consumers, channels of distribution, business circles, duration and extent of use and promotion, registration history, and successful enforcement of rights. Well-known status is granted in limited cases, providing powerful protection against unauthorized users. Marks with reputation in India, including those with trans-border reputation, are protected even without formal declaration as well-known. Section 29(4) of the Trademarks Act, 1999 enforces well-known marks by protecting them against dilution. Unauthorized use of a mark identical or similar to a registered trademark, even for unrelated goods, is prohibited if it takes unfair advantage or is detrimental to the mark's reputation. No finding of confusion is required, and marks with reputation in India, including trans-border reputation, are protected under this provision. Unconventional trademarks include smell, sound, color, and shape marks. The key requirement is graphical representation, which must be clear, precise, self-contained, easily accessible, intelligible, durable, and objective. This allows the registry, competitors, and the public to identify the mark in courts to use it as a reference in infringement cases. The challenge lies in representing non-conventional marks graphically, especially for smells and sound. Smell marks or olfactory marks face unique challenges. They are difficult to represent graphically and may lack durability and distinctiveness. While some jurisdictions have granted smell marks, inconsistency remains. The European Court of Justice clarified that a trademark must be graphically represented and durable, making it nearly impossible to register smell marks. India follows a similar approach, requiring visual representation for registration. Sound marks, such as the Yahoo Yodel or Nokia tune, can be registered if they are graphically represented and capable of distinguishing goods. The European Court of Justice and Indian law require graphical representation to be clear, precise, and durable. Sound marks may be represented by musical notation, spectrograms, or sonograms. Recent registrations in India include the Yahoo Yodel and ICICI jingle, reflecting global practices. Color marks can be represented graphically, but mere color is often insufficient to distinguish goods or services. The claimant must show inherent or acquired distinctiveness. Jurisdictions have been cautious, fearing monopolization of limited colors. However, landmark cases in the US and India have upheld color marks when distinctiveness is proven, such as the pink color for home insulation by Owens Corning. In India, single color marks may be granted protection under exceptional circumstances. Shape marks, like the Coke bottle or Toblerone chocolate, indicate origin through unique shapes. However, shapes performing technical functions or protected by design law are excluded. The European Court of Justice and Indian law require that the shape significantly depart from the norm and not be merely functional. The assessment focuses on consumer perception and whether the shape is memorable and indicative of trade origin. Domain names function as online addresses and source identifiers, much like trademarks. Consumers associate domain names with specific businesses, such as www.apple.com with Apple Inc. Registration is managed by ICNN on a first-come, first-served basis, leading to issues like cybersquatting and confusion. Domain names do not require distinctiveness, allowing unrelated parties to register well-known names and potentially mislead consumers. Domain name disputes can be resolved through the Uniform Dispute Resolution Policy, UDRP, or traditional trademark law. If a domain name is similar or identical to a trademark, registered in bad faith, or lacks legitimate interest, it may be transferred or canceled. Passing off actions may also be used, requiring proof of goodwill, misrepresentation, and damage. Courts in India treat domain names as trademarks and allow passing off actions to protect business interests. Any person claiming to be the proprietor of a trademark may apply for registration. Applications can cover multiple classes of goods and services with fees for each class. The registrar may accept, refuse, or impose conditions on the application. Grounds for refusal must be recorded in writing. Accepted applications are advertised, allowing for opposition within 4 months. After opposition is resolved or time expires, the trademark is registered, and the date of application becomes the date of registration. Once an application is accepted, it is advertised with any conditions or limitations. Anyone may oppose registration within 4 months by giving notice to the registrar. The applicant can respond with a counterstatement. The registrar then decides whether to permit registration, possibly imposing further conditions or limitations. This process ensures transparency and allows public input before final registration. Assignment is the transfer of ownership rights in a trademark from one party to another. It is a one-time activity, usually involving compensation. The assignee gains full rights to the trademark, allowing greater freedom in marketing and commercialization. Assignment conveys legal title and is analogous to the sale of tangible property, making intellectual property transmissible and valuable. Licensing is the formal granting of permission by the trademark owner to another party. It allows the licensee to use the mark on goods or services, with quality control requirements to ensure consistency. Licensing can be non-exclusive or exclusive, and all goodwill generated by the licensee belongs to the proprietor. Trademark licensing is central to franchising, merchandising, technology transfer, and software licensing, blending with other business practices. Quality control distinguishes trademark licensing from other forms of IP licensing. The licensor must ensure the licensee's goods or services match the quality of the owner's products. This can be achieved through specifications, inspections, and sample analysis. Quality control protects the reputation of the trademark and ensures consumers receive consistent products, maintaining trust in the brand. Trademark law recognizes both statutory and common law rights. Statutory rights protect registered trademarks from infringement, while common law rights allow actions for passing off with unregistered marks. Registration grants exclusive rights to use the mark and seek relief for infringement. Even without registration, owners can file passing off actions to protect their business from misrepresentation and confusion. Hallmark of trademark infringement is consumer confusion. Infringement occurs when a mark is used in trade in a way likely to cause confusion, either by being identical or similar to a registered trademark for similar goods or services. The test is judged from the perspective of an unwary consumer with average intelligence and imperfect recollection. Courts consider visual, phonetic, and conceptual similarity, as well as the overall impression conveyed by the mark. Comparison of marks is not done side by side, as consumers rarely have both marks before them. The test focuses on general impression, visual and phonetic similarity, and similarity of ideas. Copying essential features is relevant, and courts consider the nature of goods, class of consumers, and surrounding circumstances. Actual confusion is not required. Likelihood of confusion is sufficient for infringement. Passing off protects common law rights in a trademark. The elements of a passing off action are distinctiveness or reputation, misrepresentation, and loss or damage. The plaintiff must prove the mark is distinctive, the defendant misrepresented their goods as originating from the plaintiff, and that this caused or is likely to cause damage. Courts allow for imperfect recollection and focus on the likelihood of confusion. Deceptive similarity is assessed by considering the nature of the marks, degree of resemblance, nature of goods, similarity in character and performance, class of purchasers, mode of purchase, and surrounding circumstances. The weight given to each factor depends on the facts of the case. The Supreme Court has clarified that the overall impression and likelihood of confusion are key in determining deceptive similarity. Trademarks Act, 1999 provides both civil and criminal remedies for infringement and passing off. Civil remedies include injunctions, damages, account of profits, and delivery of infringing goods. Interim relief may be granted to protect interests during the suit. Permanent relief is granted at the end of the suit, ensuring the right holder's interests are protected and infringing activities are stopped. Injunctions are orders directing a party to do or refrain from doing an act. Compensatory damages aim to make the plaintiff whole, while punitive damages deter unlawful activities. Courts may grant both types of damages, especially in cases of flagrant infringement. The philosophy behind punitive damages is corrective justice, ensuring lawbreakers face financial consequences for their actions. Account of profits compensates the plaintiff with the defendant's profits from infringing acts. The right holder must elect between damages and account of profits. Delivery up requires the defendant to hand over all infringing goods, advertising, and packaging material, which are usually destroyed under court supervision. These remedies ensure infringing products are removed from the market and the plaintiff is compensated. Interim relief includes ex parte interim injunctions, and discovery of documents. Courts grant interim injunctions based on prima facie case, irreparable harm, and balance of convenience. Discovery of documents may be sought to preserve evidence and ensure fair disposal of the case. Interim relief protects the right holder's interests while the suit is ongoing. Criminal remedies under the Trademarks Act penalize acts such as falsification, false application, and tampering with trademarks. Punishments include imprisonment and fines, with provisions for acquittal if reasonable precautions were taken and no intent to defraud is proven. Criminal remedies deter infringement and protect the integrity of trademarks in the marketplace. False trademark is one that is applied without the proprietor's assent or is deceptively similar to a genuine mark. The law deems a mark false if it is used to mislead consumers or is applied to goods or services without authorization. The burden of proving assent lies with the accused in prosecution for falsifying or falsely applying a trademark. Trademark law is designed to protect distinctive marks that identify goods and services, prevent confusion, and safeguard business reputation. It covers conventional and non-conventional marks, provides procedures for registration, assignment, and licensing, and offers remedies for infringement and passing off. The law balances the interests of traders, consumers, and the public, ensuring fair competition and integrity in the marketplace.